Hello, everyone, and welcome to today's panel hosted by ECNL. We're really excited to have you all and welcome you both in Europe and beyond. My colleague Vanya will start us off with statements.
Good afternoon, everyone, and welcome, dear participants, dear speakers. Thank you for joining us today for this important discussion about the opportunities for civil society to engage in creating AI regulation in Europe. The European Commissioner Vestager emphasized the importance of being able to trust in AI systems and their outcomes, stating that trust is a must, not a nice to have. The proclaimed political aim of the AI regulation is to be future-proof and innovation-friendly, but with rules to intervene when the safety and fundamental rights of EU citizens are at stake. So the questions we really want to explore and discuss this afternoon is to what extent the existing proposal reflects such aim, and how civil society can engage with its vast expertise and experience in safeguarding human rights and fundamental freedoms. And with us today, we have a panel of amazing people, and we are really thankful for their time. And namely, we have with us Sophia Oumane from Get Up, the French organization of youth activists, Kilian Gross, the head of unit at AI Policy Development and Coordination in DG Connect of the European Commission, Sarah Chander, Senior Policy Advisor of the European Digital Rights Initiative, MEP Dragos Tudorache, the Chair of the European Parliament's Special Committee on Artificial Intelligence in Digital Age, and Richard Wingfield, the Head of Legal at Global Partners Digital. Our moderator today will be Marlena Wisniak from ECNL. She's our senior legal consultant with expertise in human rights and technology. So without further ado, Marlena, please lead us into the discussion. Thank you so much again for joining us.
Thank you, Vanya, and hello again, everyone. It's really great to see you all here. And hello to people who are watching us on live stream right now on YouTube. And so very briefly, for the agenda today, we'll start with a moderated discussion. We'll have around 35 to 40 minutes to hear from our stellar and esteemed panelists, and then we'll open the floor to you all. So feel free to post questions in the chat, and we'll do our best to answer them all within a 10 to 15 minutes, and then we'll close at around 4 p.m. CET. So let's get started immediately. And I wanted to start us off actually with Sophia. If you could share with us, to get this conversation started, what are for you some of the most pressing human rights concerns related to AI? And then we can take that conversation forward into how this is specifically relevant for the EU AI Act today.
Yeah, thank you, Marlena, and thank you for having me today and part of that important conversation. Before I answer your question, I'm just gonna tell a little bit about myself, so you know all like where I come from, and also about the organization I'm representing today. So, hi everyone, my name is Sophia. My pronouns are she, her, hers. And so I'm part of this organization called Get Up. We are based in the suburb of Paris in France. And to tell you a little bit about what we do, our goals are to challenge the current narrative that exists around the youth living in the marginalized and underprivileged neighborhoods of France. most of them are descent of immigrants, and to challenge decision makers for more equity and equality. And we'll do all this through different parent programs and initiatives, including a leadership program with which I am involved. So that was for Get Up. And to answer your question, Marlena, well, for Get Up, the use of AI in the law enforcement context is one of the most pressing human rights concern we feel really needs to be regulated by the EU. The reason why we have decided to engage in this work of understanding AI and well, at least the basics of AI, and it's because, well, while AI is present in many contexts, and especially in the law enforcement context, as the tool we all need to make everyone's life better, we realize that this is not the case for all, since the reality is that AI is particularly harmful to people of color, Black, Indigenous people of color. And as an organization that actively advocates against police brutality and oppressive policing, we have witnessed how AI could be particularly harmful to people of color in France through a recent security bill. You've probably heard of it. It's called Loi de la Sécurité Globale. And the Constitutional Court in France have recently rejected the bill because it's really problematic in like many ways. But this bill is currently being written again in France, and if it passes, it would give more autonomy to local police through many ways, including through the use of surveillance drones. And so this kind of decision making and practices is just terrible for France, for people of color in France, particularly for marginalized communities. And for us, it's just a frightening preview of what could happen on the EU level if the violations of human rights by law enforcement don't get regulated accordingly.
Thank you so much for that intro. And it's a perfect segue to go from what's happening in France to the EU level. And I'd like to hear from you, Mr. Gross. After hearing Sophia's opening remarks and hearing the impacts of technologies on marginalized and racialized groups, and especially in the context of law enforcement, I'd love to hear your thoughts about what are some of the key issues that the EUA Act is seeking to address. And specifically, if you think that the EUA Act as presented today is really effective in mitigating potential harms of structural discrimination, and relatedly, especially for people here who haven't followed the EUAI Act closely, if you could present a little bit your thinking behind creating a risk-based approach to addressing potential for harm. Thank you so much.
Thanks a lot for the question. It's of course a pleasure for me as well to be here and to have the chance to discuss with you and to explain a little bit our thinking. And you know, we are just in the feedback exercise of our legal proposals, so it's always good to get as well your feedback and your thoughts. And there's always, of course, room to improve things. Yes, what Sophia has said is of course right. AI has a certain risk because it can perpetuate discrimination which has occurred in the past. That is inherent in the technology, because the technology is based on data, and data comes normally from the past, and therefore often if you just use data from the past, you have a certain risk that these discriminations which have occurred in the past will be perpetuated and eternalized, if you so wish, if there's no human control or human intervention. So therefore I think it's time, and that's what the reason why the EU Commission is proposing this regulation. At the same time, I think nevertheless, perhaps to start from this more philosophical angle, we need as well to understand, of course, that our societies as they stand are full of discrimination and by far not perfect. So notwithstanding all the risks or the doubts, I think nevertheless that AI has a lot of potential if it's done in an intelligent way, even to overcome bias or to overcome discrimination, because we can be vigilant and we can be conscious. If we are conscious of these risks, we can use that prejudices or discrimination which we are just used to and we don't really realize can be made more manifest, or we can overcome that. So that I think we should not forget whenever we discuss this AI that there's as well an opportunity that certain things may become better with AI if, for instance, if we take these precautionary measures. And that is, I think, the starting point of the Commission, because we believe that AI has a lot of potential, not just for the economy, but as well for society. And we have seen this in the COVID crisis, for instance, on vaccines or on CT scans for COVID diseases or another area. So it can do a lot of good things, but there are areas where there are risks, and that's why we have this risk-based approach, because we think there's a number of applications where there is basically no human intervention, like your spam filter on your mobile or predictive maintenance in the factory, so we don't really need regulation for this. But there are areas related to safety, which is as well a fundamental right in the end, and to fundamental rights as such, where AI can be very sensitive because it has this tendency of being dependent on past data, and where corrective measures may be needed in order to get it right. So we have taken a risk-based approach where we try to identify, you can see this in Article 7, where we try to identify on the basis of evidence criteria how harmful a certain use can be and how reversible or how likely this harm would be and how reversible, for instance, the harm could be. So how important it is to take precautionary measures. And we've identified 8 areas where we think that harmful AI could occur. And among these, you find in particular law enforcement, you find migration, asylum, border control management, administration of justice, and access and enjoyment of essential private services and public services and benefits. Because here, these are areas where basically the individual is subordinated to public authorities with public power. So there is not an equal level playing field, but here the individual is exposed to the public. And that is, of course, always where the human rights or fundamental rights have been born. So there is an exposure situation and therefore a particular sensitivity of fundamental rights. We have identified then in these areas use cases where we think there is high risk. This we will, in the first go, we will look at these use cases. These are the cases which we consider high risk and where we will ask for our assessment. This list may be amended because we wanted to make it facts-based, because we don't want to speculate. We want to look where risks have occurred. And we will amend this list and we will scrutinize this process because this is a very fast-moving technology. One of the advantages of this horizontal regulation is, in our view, that it allows us to move quickly, because whenever we identify new use cases in these areas, which are relatively wide, we can act and we can include them. And we think that the problems which are mentioned are well covered in the 5 requirements which we have listed up. Namely, I want to mention in particular data, because we want to make sure that the data are representative and free of bias as far as this is possible. We want to ensure human oversight, so there should be a human in control of the device taking final decisions. And there should be sufficient documentation and information so to allow auditability and redress. So this, in a nutshell, is a bit why we think that this is a good answer to take out the benefits of AI, to allow the benefits of AI to develop, but as well to mitigate and to hedge the risks. Thanks.
Thank you so much for that, Mr. Gross. And as a response, I'd love to turn to MEP Tudorache and hear from you. To level up a little bit, where does the EC's proposal fall today within the EU legal framework? And what are the next steps regarding the development of the Act? And this is, really where a lot of the efforts for advocacy now and understanding of next steps will be at the European Parliament level. So if you could walk our participants through that process, that'd be great.
I'll do that with pleasure. Thank you very much for having invited me. Good afternoon to everyone. Where does the proposal fall? Well, it falls into a puzzle of other proposals, which all together are meant to guide us in the digital transformation that we have all embarked in. And which has been very much accelerated over the last period of time, even more so during the pandemic. And if we see, in fact, the whole series of proposals coming from the Commission in the space of the last year, it's clear that the AI Act is, again, one piece in this broader regulatory exercise, regulatory framework, which the Commission has endeavored to put on the table. And that is a good thing. I want to say it from the start. The fact that we have reached that stage where after preparation, after a lot of strategic preparation, after putting also investments into place in the MFF, in the recovery funds, so on and so forth, it was high time that we at the European Union level arrive with legislation, among others, for AI. So again, we have to see this act, we have to see this proposal not as a standalone, not in itself, but again as part of this broader array of documents and proposals, which are meant to cover responsibility for platforms and marketplaces and for all digital operators, the DSA, the DMA, also issues related to the governance of data. We have the DGA, we're going to have further proposals in terms of data management, data flows, all that, again, part of the same drive to adapt our societies, to adapt our economies, to adapt even our democracies, in fact, to the digital realities of today and of 10, 15, 20 years from now. What follows next? You also asked me. Well, what follows next is, I think, whereas the work done certainly by the Commission up to now was very important, all the consultation done around the white paper and the proposal itself, but the really important work, political work, starts now with the preparation of the negotiations in the Council, in the Parliament, and then with the negotiations themselves, the trilogues that will, I would dare guess, take quite a bit of time. Why that? Because there's quite a lot to negotiate, there's quite a lot to tweak in the proposal. And I can anticipate, also based on the work that was done here in Parliament over the last 2 years, a lot of resolutions on AI, looking at the different perspectives and the different angles, the different implications and impacts of AI. Also the work done in the committee that I chair in AIDA, where again, we have tried to not necessarily look at today, but also look at tomorrow again, and at the horizon of 10, 15, 20 years from now, and really understand the deep implications that this technology may have on what we do and how we do it. So again, the process that starts now is going to be a detailed, complex, long process. We are yet to determine here in Parliament which will be the responsible committees. We have IMCO for now, the Internal Market Committee responsible. There is also a claim from the LIBE Committee, where I also sit, which is supposed to be decided soon, whether it will be jointly responsible together with IMCO for the AI Act. Depending on that decision, there will be, again, a joint preparation, a joint responsibility in the two committees, which certainly will make the work even more complex, and the need for coordination very complex as well. And here, going back to the first part of your question, I would say something that I have said in previous occasions before in other settings. For me, the very important thing now, because the AI Act is not a standalone, because it is part of a broader framework, it is essential that we, as we negotiate them, that we move as a common front. And that we don't do that only in the Parliament. I think the Council should do the same thing. In other words, that we coordinate the negotiations so that we make sure that we don't go in one direction, in one negotiation, and we take another direction in another. And that from governance all the way to the details, we arrive at the very end with a coherent framework. We are now writing the rule book for the digital world of tomorrow. We also we have this expectation, this objective even, I would say, that we would also be influencing the way this rule book will look at the global level. So we like to think of ourselves at the EU level as the ones, as trendsetters, in legislative, in normative terms. We've done that with the GDPR. We would like to replicate that exercise now with what we do with AI, what we do with DSA, what we do with VMA. So we would like to see the standards that we are setting now become also possibly global standards, and that we do that together with other like-minded partners. Well, to do that, again, this framework that we are developing now has to be coherent. We have to show that we have that capacity at European Union level and at our institutional level to, again, negotiate this in a way that makes sense, and that we also lay down a governance at European level that makes sense in terms of how we manage this transformation. So a lot of challenges, a long and complex process, but I am optimistic that this would fall into the right places in a way, because I think we've grown a lot as an institution, as regulators over the last couple of years in educating ourselves as politicians to what is behind these otherwise very technical, very sometimes difficult if you're not particularly digitally native, as many of myself and my colleagues are, but to get to a level where we have amassed enough information, and also thanks to events like yours, and also interacting with stakeholders from absolutely all walks of life and all areas of activity, again, to make sure that what we do and the kind of definitions that we'll end up putting in this text and the conditions and the criteria and all of these rule books that I mentioned earlier is one that is adapted to the technology requirements, but also adapted to what the society expects of them as well. So this is a bit where we are. I think the work will start soon. A lot of groundwork was done already, and we're ready to engage in a way.
Thank you so much, MEP Tudorache, and absolutely agree that one, there is here an opportunity for global standard setting, and especially for our participants who aren't part of the EU who are watching today. We really would love to hear your voices and like to get you involved. And also, like you said, it can definitely appear daunting and complicated given the terminology is often so specific, and not a lot of people have expertise in this field specifically. And yet one of the goals to get more people involved is to really recognize that everybody does have lived experiences and try to make this as accessible as possible. And thinking about some of the specific elements of the Act, diving deeper a little bit more, I'd love to turn to Sarah from EDRI and hear a little bit about your thoughts regarding bans. So for participants here who are new to the topic, the EU Act does include some pretty notable bans of biometric surveillance technologies, yet there are also significant exceptions, not least for things like criminal justice, national security, and counterterrorism. And so, Sarah, I'd love to hear from you. How would you assess the prohibitions in the Act today? And specifically, what are your thoughts as to whether they protect vulnerable and marginalized communities, and especially racialized people, from harm? Thank you.
Yeah, thanks so much, Marlena. And I would just like to echo what all of the other speakers have said so far, that I think it's so incredibly important that we have discussions like this, where we have a range of different stakeholders from different backgrounds, different disciplines and areas of work come together to discuss this law. I think increasingly with the question of AI regulation, we run the risk of having a highly technical conversations that don't always fully engage to the extent that we need to the people that are impacted by the systems that we're talking about. So I think that it's really great that we're all here. Before I talk specifically about bans, I maybe would just like to speak a little bit to the framework in general, particularly vis-a-vis discrimination. So I thought Mr. Gross really rightly identified that there were, in the high risk sort of determination, that there are some cases of some uses of AI that pose severe risks for people, and perhaps in particular marginalized groups. And so we see that the Commission have identified sort of a list of high-risk areas that potentially pose specific risks for human rights and impact on people. However, when we look at that list, we see that although it is changeable and updatable to some extent, the general areas are fixed. And so we don't necessarily have the opportunity to update completely new area in that, to have completely new use cases of AI in new areas, although we can update them within the existing categories. Secondly, then we also have this question of self-assessment. So we've identified some very potentially harmful applications of AI. However, for the majority of the applications in the current AI Act, as it's proposed right now, the compliance with the law is assessed by the companies themselves. Now, this, I think, poses a problem because the companies that are developing these AI systems have a vested interest, they have a profit motive to demonstrate their compliance with the law, to demonstrate that they are, in fact, free of biases, have good data quality, that meet all of the very good requirements that are set out in the law. So this is, I think, the first thing that we really need to be careful about when we're talking about systems of governance for AI systems or any socio-technical systems that impact people. We need to also ask, what are the interests of the people involved, and how will the enforcement structure, the conformity assessment structure, allow for an independent way to assess not only the impact of these technologies, but the compliance with the law. So that's the first part. I think then with the question of discrimination, which I believe that many people in this room would probably be very interested in, EDRI have been really, we've tried very hard to sort of understand how AI systems can perpetuate discrimination specifically. I think that we can summarize in this debate, there's sort of two main approaches. The first is the notion that we can see that all of the discrimination comes from poor quality data. This is a discussion that comes up a lot. We have bad data and this causes discrimination and therefore bad outcomes for people. This is not necessarily untrue, but I would like to offer an alternative viewpoint, which is that actually when we look at discriminatory AI systems, many of the harms that at least civil society have uncovered across the world with these systems, they don't necessarily lend themselves to improving with different data sets. Most of the requirements in the AI Act that propose improvements to potential discrimination, they focus on data quality obligations. So in Article 10, we see that high-risk AI systems, developers of those systems should examine for possible biases. However, I think this, particularly with some of the use cases that have already been mentioned, predictive policing systems, various different types of uses of AI at the border, also uses in the education or the employment context, worker surveillance, for example. Many of these systems will inevitably exacerbate structural inequalities. Why? Because I think, as Mr. Gross himself notes, discrimination is rife in our broader society. And AI systems are deployed in this wider context of structural discrimination. As such, there isn't really any unbiased data in policing. There's no process of welfare risk assessments that doesn't overly focus on poor people. There's also no context in which we can extract data from migrants or monitor precarious workers that doesn't perpetuate significant power imbalances. So the AI that we're talking about regulating is therefore inherently and sort of irrevocably tied up from these situations of structural discrimination. By relying on very technical ways to improve that, technical checks for bias, as a response to this structural discrimination, the proposal risks reinforcing this harmful suggestion that removing bias and discriminatory possibilities from these systems is even possible, when in fact, in many use cases, the structural discrimination is tied up with the very deployment of these systems themselves. Technical checks from the actors that profit from these systems will not help us solve the discrimination that they evoke. I can speak a little bit more later, if that's interesting, about some of the other suggestions for changes that we might see that could maybe address some of these discriminatory outcomes. But maybe I should answer your question, Marlena, about the bans, which I can do. So EDRI, which I'll post a little bit later, EDRI have published a really short blog post which just outlines some of our main thoughts on the AI proposal. But specifically with relating to the bans, EDRI have a campaign called Reclaim Your Face, which calls for a full ban on biometric surveillance practices in publicly accessible spaces. We believe that we have seen the rise of facial recognition and other sort of systems which extract data from us, use our faces, bodies, behaviors against us in the public space. And that has been recognized by the Parliament, by the Commission, has very potentially severe consequences on our democratic society. So the current, for those that haven't seen the full act, the current law suggests that there is a ban on some specific uses of biometric technologies when deployed by law enforcement. However, what we've identified is that the approach to biometric identification in other cases means that there is not necessarily a full ban, the full ban that we are calling for. First of all, we've seen some really wide exceptions, as you've already noted. So meaning that the police could use facial recognition or other biometric technologies in a range of different contexts, which potentially is a ripe for abuse scenario. Secondly, we see that this ban doesn't necessarily apply for other authorities. So for example, schools, local governments, shopping malls might use facial recognition technology, and this is not banned in the current proposal. So we see there that actually the act falls short of what civil society have called for, what many people have signed the European Citizens Initiative. We've had around 56,000 signatures, and all of those are calling for a full prohibition on all forms of biometric mass surveillance practices in public spaces. And this we have unfortunately not seen in the act, although of course there's scope for change. And then I know I've been speaking for a while, but if you allow me, I will just speak about some of what is missing, because I think that this follows a really well from Safia's point that she has made. There are some use cases that have been classified by the Act as high risk. However, most civil society that have been active on this file have called for them, instead of to be categorized as high risk, subject to self-assessment by companies, have actually called for a prohibition or more stringent limitations on these technologies. So the first is forms of systems which use predictive modeling or the attempt to predict future criminality of people, otherwise known as predictive policing, which seek to forecast either where or by whom certain crimes are likely to be committed and predict people's future criminality. We've seen that such systems, as they're used across Europe, repeatedly score poor people, working class people, racialized and migrant communities with a higher likelihood of presumed future criminality, and as such need to be more stringently regulated and prohibited in the Act. The second are uses of AI in the field of migration control, which is a situation of severely significant power imbalance and have huge implications for people's fundamental rights. And this also is categorized as high risk, but not prohibited in the Act. And then the last, and I think this is echoed by many unions, including Uni Global, are various different forms of worker surveillance technologies, which have highlighted some really highly intrusive practices, intensive monitoring of workers, precarious workers, to meet performance targets, and various other sets of measures which limit their autonomy, diminish their well-being, and limit workers' privacy and other fundamental rights. And other unions and other organizations have also called for more stringent rules in the Act to limit such uses. So I think these are some of the things that, just with respect to bans, that I think the Parliament and more specifically civil society will see push for in the future. I have to say that we've made some really positive progress in the fact that the Commission has introduced this criteria, Article 5, which has allowed for the possibility and the acceptance of the notion that some AI systems pose an unacceptable risk to our society. I think this is a very positive step that the Commission has taken, but on a fundamental rights basis and on this analysis of what does structural discrimination mean with respect to AI systems, we think that they need to go further. And thanks for bearing with me with the long answer.
Thank you, Sarah. Long answer, but there's a lot of context setting, which is super important. And I wanted to follow up on the last points you made on some of the specific technologies that are considered as high risk by the Commission, the current draft proposal, but are not prohibited. And two that are on my mind specifically are emotion recognition and gender and sexual orientation recognition. And I'd like to turn it over to Richard, who hasn't spoken yet. And if you could briefly share some thoughts about two of these systems, for example, and what would the human rights risks of such systems be?
Great, thanks so much, Marlena. So I think the first point that I'd like to make when we're talking about the development of some of these technologies is that even if they are created for purposes that might be legitimate in very specific circumstances, we all know that data leaks. Data is leaked, data is shared by people within organizations, data is hacked into by governments and third parties. So we always need to bear in mind, not only is how is this data or how are these technologies being used in this very specific way, but what are the potential consequences were that data to be leaked, to be obtained in some other way. And I think that's a really important consideration when we're talking about AI technologies or forms of machine learning that try to determine what particular group you belong to or a particular characteristic that you might possess. And we know that many companies want this information because it allows them to target you with ever more specific advertising. It makes their products and services more attractive to others who want to be able to sell or market their goods and services to you as well. Thankfully, in Europe at least, we're not in a situation where we have governments who are trying to identify, whether you might belong to a particular sexual orientation or not, but we know that that is something that does exist in other parts of the world. So if we're looking at those kinds of technologies, anything which tries to identify what particular characteristic you possess or group you belong to, the real risk there is that often that data will then fall into the hands of somebody who wishes to discriminate against people belonging to that group, perhaps even use violence or some other kind of human rights violation against them. I say that thankfully we don't live in a continent where there exist governments who are trying to identify people belonging to a particular sexual orientation grouping, but we also know that there are state actors across Europe who use disproportionate force, for example, when it comes to law enforcement against persons with particular racial backgrounds. Unfortunately, we're in a situation where even something like sexual orientation and gender identity is still something that comes under criticism by governments in Europe, and where we've seen in the last few weeks measures being put forward which disadvantage and target those particular groups. So I have a really strong concern about any kind of technology which seeks to predict a person's sexual orientation, religious grouping, any other kind of characteristic, because we know that discrimination exists. And if you know someone belongs to that group, it's going to be a lot easier to discriminate against them. But briefly, I'd also want to mention that even sometimes technologies which might be used for good purposes can still have harms which are sort of inherent in them. And this really links to perhaps some of the points that Sarah was made. You could imagine a situation where emotional recognition might be used for legitimate purposes. Maybe, for example, an employer genuinely wants to make sure that the workforce are happy and is concerned about staff morale. And at the moment we do that through, I don't know, staff surveys or what have you. You could imagine a situation where in limited circumstances, that technology might be used with good intentions in mind. But we also know that the best laid plans of mice and men, often don't work out. Even something like recognizing a person's emotion, we all assume that that's relatively straightforward. But say, for example, you have persons with certain facial disfigurements or disabilities, the technology is probably going to work differently or not be accurate in those situations. As Sarah's pointed out, there are dark biases in the data sets themselves, which might mean that something like emotional recognition technology works very well for people who belong to the majority ethnic group, but isn't less accurate when it comes to minority groups. So even technology which might be done for good purposes, and I'm not saying that is a good purpose, but even if you could imagine that it were, the accuracy rates mean that some people might still be targeted and disadvantaged by it, simply by its utility. So those are the kinds of things that I think really need to lead to the Commission and other MEPs involved in this process to think, are there genuinely legitimate reasons that this technology could be used, or are the risks of its use and the risks of the data created being leaked or hacked so great that an outright prohibition is necessary?
Thanks so much, Richard. And before we move on to our last topic, which is specifically on participation, I just like to get back to MEP Tudorache and hear some of your thoughts after hearing from Sarah and Richard about the bans, and especially also now that I think it was just last week, or losing track of time, the EU Data Protection Board and the European Data Protection Supervisor have also made very clear calls for prohibition on certain harmful use cases of AI, such as biometric mass surveillance, predictive policing that Sarah mentioned, and also uses of AI at the border. And I'd love to hear from you, how will the Parliament, or how your thoughts about how the Parliament will ensure that these concerns are addressed. Thank you.
Well, I would like to send you very easily to a document that will all say that. Unfortunately, it's still in the making. One of the reports and opinions that the Parliament has endeavored to prepare ahead of the proposal of the Commission, with the objective of politically signposting a bit the work done and to make clear the views, the stand of the Parliament on key topics. One of those documents and one of those exercises was supposed to be about AI and its use in law enforcement, particularly because this was one area that us, but not only us, a lot of stakeholders were identifying clearly as potentially breaching or bringing risks, very high risks in terms of privacy and rights of individuals. And everything from mass surveillance to biometrics to facial recognition, predictive policing. So these were areas which we've debated on quite a lot ourselves here in the European Parliament. So again, we had started this exercise on AI in law enforcement. Unfortunately, we had to change rapporteurs. I am also a shadow rapporteur on behalf of my group for the preparation of this text. The good news is that now we are very close to finishing it, a bit late, again, because of some procedural shortcomings along the way. But you will see in that document that we as Parliament are speaking very clearly, precisely on those points. You will see what the position is. I can't tell you because it's still internal work in Parliament and it's still going through some final tweaks. But overall, there is a majority now. There is a majority behind the text, and there again we address issues such as predictive policing. We address the issues on use of biometrics and related technologies, mass surveillance in public spaces, so on and so forth. And now I also have to say that if we look at the way the Commission has approached it and has looked at it, they come exactly from the same direction. Everything about the whole point of human centricity of AI, of this technology, is about being very careful on how we regulate these particular aspects and how much we allow this technology to be invasive in terms of this set of rights. So already, I think the proposal of the Commission is going in the right direction. There are clear prohibitions for certain types of technologies. Others are put in the high-risk categories, which means that there is an assortment of safeguards which need to be respected. Whether that is enough, or whether we would want to go further or nuance some of the proposals of the Commission, that remains to be seen as part of the negotiations. I expect that these will be the areas of the proposal where most of the political debating here in Parliament will actually be done, and where also a bit the ideologies from the various political groups will play out. On the other aspects linked to the potential of the technology, to how we are setting up the business environment for it, regulatory and governance there, from all of the debates that I've witnessed over the last year, I see that there is quite a lot of convergence between the political groups, which means that this area linked to the impact of technology on human rights, on fundamental freedoms, is going to be, again, one of the political battlegrounds where we will see an ideological manifestation playing out as well. So to sum up, this is pretty much where we stand. And once the document is going to be adopted, it passed our committee, is going to go, I think, to the plenary in next week, in fact. And then you will see very clearly what the standing of the Parliament is on this.
Thank you so much. And I would like to give the opportunity to respond very briefly, if possible, in maybe a minute or something, to Mr. Gross, and then follow up a little bit on your points, MEP Tudorache, on like what will be the heart of the heated political debate going forward with respect to human rights, and how civil society, more broadly, as many people as possible, and especially marginalized communities, can actually participate in this political debate. So Mr. Gross, just a few reactions on the ban specifically, also for the call of the EDPB and the EDPS for a full ban, and if you have any reactions to that.
Thanks. 1 minute will not be enough to react to all this. I'm sorry. You're not too generous with me. But I will try to give you a few ideas and not to extend too much my time. Well, we of course know the position from EDRI that was submitted to us in writing, and it's a very, very valid point. Perhaps I can explain a little bit what was our thinking behind this, why we came up with this proposal. We should never forget perhaps two things to bear in mind. A ban is of course a very sharp word, because it means you can never allow something, or you really you push something completely out. So you have to be sure that there is no meaningful or no useful application of something. Otherwise, it doesn't make a lot of sense. And we need to see as well for these bans, of course, that we are not acting in a complete isolation, because we have as well other rules in place. This is in particular important on this item on biometric identification, where we have already very strict rules in the GDPR, the General Data Protection Regulation. For instance, in Article 9, normally there is a prohibition to process biometric data unless there are very clear-cut exceptions, or in Article 10 for law enforcement purposes. So we need to see this in that background, that our act is not the only act regulating something. I think MEP Tudorache put that very well. It's a part of the puzzle, and we need to see the overall puzzle, which should make sense in the end. We need to not to duplicate a prohibition, which, for instance, is already in the GDPR in our act. Of course, this is a very political discussion, in particular on biometrics. We think, nevertheless, that we need to try to balance as well a bit the different interests. We have expressed ourselves in favor of a ban. I think we should not underestimate what we have put there in the exceptions, because we clearly identify when member states may introduce exceptionally, let's say in particular exceptionally, such a biometric tool. They don't need to do it, but they may do it. They will as well then need a law to justify the data processing. But for instance, they can never do it 24/7. So they can only do it within these specific use cases which we have identified, or specific exceptional cases which we have identified, which need always individually be controlled by a judge or by an independent authority. And by doing so, we hoped to find a balance between different interests, because terroristic threat, for instance, is as well, of course, an important interest. And for those member states who believe, we don't prescribe anything to anybody, but for those member states who believe that biometric identification in the public space in exceptional circumstances can help them to fight that threat, we think it would be a bit, would go very far to completely deprive them from that possibility. On the other exceptions, on the bans, this is a bit the same. I mean, you need to think a bit about whether you are completely sure whether you never want to have any kind of these uses, or whether you are sure that all these uses are harmful. This is indeed the key question which you have to ask yourself. I know when you speak about predictive policing, we put it clearly in as a high-risk case, so we put quite clear requirements. But we are not, at this stage at least, but we are open for discussion and to learn, but we're not convinced that all uses, for instance, of this tool are automatically harmful, because, for instance, we spoke to the German police, who uses such a tool in a quite transparent way in order to inform house owners of the risk of burglary. And we're not completely sure that, for instance, such a use would automatically should be prohibited. So you need to really reflect before you, in this discussion on bans, I would call as well to take always into account what do other acts say, because the AI Act is not the only act of the acquis, on the contrary. And are we really sure that we would not take out relevant or useful use cases, bearing in mind that the reality as it stands now is not at all perfect neither. But I stop here because otherwise I have exceeded my time limit tremendously.
Thank you so much. And I wish we had more time and also to discuss in more depth what you said, to follow up very briefly on some of the exceptions on temporal. Indeed, there are, as well as geographical for zip codes. And yet there's still the conversation about assuming that the world is not neutral and we do live in systemic discrimination. How do these geographical exceptions, for example, not perpetuate surveillance of neighborhoods that are already highly surveilled? And so these kind of questions and others are really only possible to raise when we bring in marginalized groups, especially racial, ethnic, and religious minorities, women and gender non-binary persons, LGBTQI communities, and refugees, migrants, among others. And so, Safia, I'd like to turn it back to you, who are a direct representative of the community here. And when you were participating in this debate, and from the white paper to today, and hopefully going forward as well, what are some of the biggest challenges that you've experienced? What are some, voices that are glaringly absent from the debate that can really push back against many of the provisions that appear neutral at their face, but that actually can perpetuate or even exacerbate discrimination? And what would you recommend we do to include those voices, and how can you, empower others that are listening to us today to really, participate as best they can?
Yeah, thank you for your question. It's it's funny that you mentioned the white paper, because as an example, because actually put a note about it, because in the conversation I heard the rule book being mentioned a lot, and I don't know what a rule book is. And same thing for white paper. The very first time I heard just the name white paper, I was like, what is this? Today I know, because I went ahead and looked for the information. But so one of the very first big challenge is the language barrier, whether it's technical. We talked about it today. Even in today's conversation, there were a lot of acronyms being used I'm not familiar with. So thank you, Marlena and Vanya, for the translation. But when as a civil society organization, when we do our own research and we see all these terms used, that's a lot. So language barrier, not only from a technological point of view, but also from the advocacy, in the advocacy context, because in our advocacy work, it's one thing to want to engage in advocacy work, but when you're not familiar with this, when you have never done this before, you want to do it, but it's extremely challenging. It's not everyone is here waiting for us to listen to us and make all the changes that are needed. So this is one thing. And also on language, when we look for resources, and I'm speaking as a representative of an organization that is from a French-speaking country. When we go look for information and resources, they mainly exist in English. For GetUp, we are very privileged because we have some members that are English speaking. I am one of them. I'm comfortable speaking English, communicating in English. But what about other organizations? This is a privilege that not everyone has. So language barrier, one thing, and also the lack of resources. To give you a clear idea, I'll tell you what advocacy work around the EU AI Act means for GetUp, and I'm sure for many other organizations. So what we're going to do about it, we're going to search about it, we're going to review it, we're going to understand it, or try to understanding and find a way to consult with individuals and other organizations, hopefully in France, if we find this, and within the EU to be able to give, like to understand it fully and understand how it will affect our community and then advocate accordingly. This might sound like an easy task. However, for us, that means a lot of time that needs to be taken just to manage, to gather a team of volunteers, to coordinate this work, and we'll need to take the time to train ourselves to do so because we're not expert on the subject, and we also need to take the time to train ourselves to advocate for our community at the EU level, since we don't have the tools to answer that our voices will be heard. And this also represents a lot of time that is being taken away from all the many other projects we are working on and directly with our community. And as for like ways that could like help a civil society organization like to better include us in this conversation, in this work, I don't know how that would work, but that would, like in our mind, that would really help to have like representatives within the EU institutions that outreach to us, that communicate with us, that represents us, just to make our work easier. And one aspect of the work of GetUp, and I'm sure for many other civil society organization, well, our organization exists thanks to funding from the government. This is a great thing from a financial point of view. However, it also removes some of our autonomy and freedom in our actions and in the way we take a stand on political issues. So pretty much we can be very limited in the actions we want to take to better help our community because we are the ones who understand them the best. And so like I said earlier, wanting to be involved in policymaking is one thing, and advocacy work as well. This is one thing, but actually getting in this process is extremely challenging. It's not welcoming, it's intimidating, and for all the reasons I've mentioned. And so being able to work closely with a representative, again, and I'm not sure how that would work, but that would really help us in our advocacy work on the EU level.
Thank you so much, Sophia. And a clear call here to representatives and people and policymakers generally to include affected communities. And before we turn it over to audience questions for the last 15 minutes, I would like to give an opportunity to MEP Tudorache to respond, and especially given, like all the future political debates that you mentioned, the opportunity to engage. I'd love to hear from you. What are your plans at the European Parliament level to include groups like GetUp and others across the Union, and also, specifically ways to address power imbalances between different external stakeholders, because we often talk about multi-stakeholder engagement, but the reality is that civil society groups, especially grassroots organizations, or the ones that Sophia mentioned, lack resources, and they're not in a level playing field with trade organizations, larger specialized CSOs, and obviously the private sector that can send out armies of lobbyists to Brussels immediately. So yeah, I would just like to hear your thoughts, and then we can open it up to the audience for questions.
Well, I think it's important to say from the outset that starting with the white paper, I'm sorry that I'm using it now. I'm hoping everyone is familiar with the process. If we see also how the Commission has approached the consultation for this particular act, I always like to use it as an example. Why? Because I think it did provide as much of a level playing field for all stakeholders to contribute as possible. Of course, there's always room for better. And I fully take the points, the arguments that Mrs. Urmane made. There are certain things that are intrinsic in the way certain organizations work and how they represent communities that come with certain barriers that we don't even imagine sometimes from a regulator's standpoint, from language barriers to access barriers to even access to the right infrastructure that would actually allow you to even go as far as doing a research and maybe loading your contribution onto the portal made available for that. So again, there are intrinsic injustices in the way the society works, which are clearly providing barriers for all to contribute. But I think given the circumstances, again, what the Commission has done with the white paper, I think did open up as much as possible the debate and the consultation to many. And in a way, contributions came in. I was following the process quite closely myself. Contributions came in from all walks of life in the same way, whether they were a big tech company or whether they were a small NGO. Secondly, we have tried as much as we could also here in European Parliament to do the same. I can tell you, I invite you to look at the agenda of every hearing or workshop that we have done in the AIDA committee since the start of the committee in September last year. And you will see that in every panel or in every hearing where we had two panels, we always tried to balance out the representation in these debates to make sure that we always have as many perspectives as possible, and always to include also perspective coming from civil society organizations, from NGOs, from activists, depending on the topic that we were discussing. Whether we were discussing the impact of AI on the Green Deal, we brought in forefront activists to make sure that we also hear their side of the story, that we also understand that perspective. When we had a hearing recently on AI in agriculture and farming, we again had activists very, very much fighting the good fight for a safe and sustainable development of farming, to bring in their perspective and make sure that we are not only looking at the technological benefits of AI, but we also understand what can be the implications in terms of sustainability. So again, we have tried in Parliament already so far ahead of the AI Act and ahead of these negotiations to ensure this level playing field. And we've had debates where this, particularly at the beginning, where the issues of biases and injustices were really prevalent in our preoccupations, in our debates. Then we try to bring in even more than other representatives, particularly those coming from the industry, to bring in associations, again, organizations that are promoting, that are advocating for fundamental rights, freedoms, and rights of different communities. I think it's something that we need to continue to do from now on as well. So as we are now embarking in the process of preparing the negotiations and then the negotiations themselves, I think we need to make sure that we, and when I say we, I mean a collective we here in Parliament, because the committee that I chair, AIDA, does not have a legislative role. So we will not play a formal role in the negotiations of the AI Act. The standing committees, IMCO and probably LIBE as well, will be the ones that will be leading the negotiations formally. But again, all of us that are working on this file will need to continue in parallel with the negotiation process to listen to all the voices and ensure in all of these interactions, hearings, debates, make sure that we have a balanced intake of data, a balanced intake of perspectives to make sure that we are well educated and broadly educated when we make our judgment calls politically in the contributions that we make. So it's it's something that we are very mindful of. There's never enough, but it's something that we are very keen to establish and to maintain as part of these negotiations.
Thank you for that. And one opportunity we have to do that today is actually giving the floor to some of the participants. And there are a few who would like to voice a question. So I'd like to start with Roxana. If you could briefly introduce yourself and ask your questions, and given how short we are on time, if you could keep the questions short and the answers as well limited to 1 to 2 minutes, please. Thank you, Roxana.
Thank you, Malina, for giving me the excellent. It's a pleasure.
I think you're having audio issues, Roxana. Can you speak a little bit louder?
Do you hear me?
A little bit better now, yes.
Okay, I will turn off my video camera and I hope it's better now. Dear Excellencies, I was carefully listening to your remarks, and I would like to start off with some remarks as well before posing my question as short as possible to you. My name is Roxana Lorraine Witt. I'm head of Safe Space, which is the only Romani-led and founded organization in Europe with a focus on digitalization as AI, facial recognition, and so on. And I am one of 2 experts in the whole Romani European community on these matters. Neither me nor my dear colleague Benjamin was consulted in any of your consulting rounds, to be honest. And neither did any of you consider consulting any Romani representative I know, and I know many Romani representatives. The reason I am here today is because EDRI did this, which is not EDRI's, it's not their task to consider the Romani people, which make up to 22 million people in Europe, European citizens that pay taxes, that pay you to do legislation for us and to assure that we are secure and safe in the European Union and in Europe. However, Mr. Gross, you mentioned the German police as an example, how they successfully use technologies like AI, etc., and biometric data collection as a use that could be a role model for future use of other European states where AI is successfully used prevention of criminality. However, the German police is very well known to illegally collect biometric data of Holocaust descendants, which is what the Romani people in Germany basically are, and use it for the persecution and racial profiling. So I think the example you have given to us is a perfect example why these technologies should be banned completely for the safety of the most vulnerable groups in Europe. So what I came here to ask actually is, as I have seen the paper, the white paper, that there's literally most of those who created that white paper, or the majority of them were white people, exclusively white people, and those discussing the white paper and the legislation on AI in Europe are mostly white people who have or who bear a lot of biases against Romani people in Europe and other multiple marginalized groups. How will you ensure that in the future those biases in the legislation process will be erased? How will you consult or ensure consulting of those who haven't been consulted or involved in the consultation up until now? And how will you ensure that those that are creating progressive technologies such as AI, such as recognition systems or whatever, do have to go through or undergo mandatory training to confront their own biases and racist prejudices and other things to prevent that those prejudices and biases will influence the future creation of AI or other progressive technologies, as you just mentioned, all of you, that with this legislation you plan to influence global and national or EU-wide and global standards on digitalization. Thank you.
Thank you, Roxana. And given how short we are on time, I actually would like participants to ask questions first, and then we can give a few minutes to respond. And Meher, from European Disability Forum, I think you had a related question. So if you could briefly, please, ask the question.
Thank you. Thanks a lot for allowing me to speak. You can hear me okay, no? Yes, I would like to actually echo a bit Roxanne's comment about involvement of civil society in the consultation process. We are quite active in participating as EDF, which is the European Disability Forum, representing 100 million people in the EU, EU citizens with disabilities. So we have participated in the consultation for the white paper. We are quite active generally on EU policy development. But again, with the DSA and DMA and also with the AI regulation, we unfortunately see that these views are not being considered properly. I mean, it's one thing to do the consultation process. The other thing is actually to take the views of people that will be affected by EU policy on board. So I think this is an important thing to remember. And in terms of accessibility, which is important for persons with disabilities, we see that in the regulation now we have quite a paternalistic approach, I would say, to ensuring right of person with disabilities, because it is included in as a non-binding voluntary measures for non-high AI for companies if they want to do. It's similar for the ensuring the diversity of developing teams, etc., etc. You have seen probably. But I think as a signatory of the UN Convention, the EU has the obligation to ensure accessibility as a right and not as a favor or as something additional to its citizens. So my question to Mr. Gross would be, how much would the European Commission be open to revising its position in this regard? And we also count on the European Parliament support to improve legislation to ensure that rights of persons with disabilities are protected. I could go on a lot of different aspects, but I will just share that, say that we share a lot of the concerns that Edri, Sarah raised, and also I think Bayuk raised some points in their first reaction about consumer rights, but we will develop and publish our position and surely share it with you in the coming months. Thank you.
Thank you so much. And last person, very briefly, and then we'll go to reactions and concluding comments. Claudia, who asked a question. If you'd like to really, just a question, please. Is Claudia here? If not, no worries. So Mr. Gross and Tudorache, very briefly, we addressed many of the questions of consultation, but specifically with respect to Roma persons and persons of disability. And then Sarah, Sophia, and Richard, you can have 10 seconds each to give one closing sentence. So prepare well. Go ahead, Mr. Gross.
Thanks a lot. I will try to be brief. Just to clarify, I did not say that everything the German police is doing is great or perfect. I'm far from that. I'm not a German policeman, and I'm not even an expert in German policing. I referred to one example where we had a presentation by the North Rhine-Westphalia police on a project on house burglaries. So that was all. I mean, I see in the chat that there's a lot of discussion about other things which may happen or not happen in Germany, but that was not my intention. I was just trying to show. And again, from the Commission, we have as well said in the one recital of this AI Act that not because something is high risk, it should be by any means be allowed. It can still be prohibited by other acts of EU law. We just think we have not banned it. We have made it high risk, so we have restricted it. And it still has, of course, to respect all the other acquis, and nobody is, of course, obliged by any means to do that. This is, of course, still a political decision whether you think in a society you want to do that or not, just not to misunderstand me. On the question of the consultation, I'm sorry to hear. I think Dragos explained it very well. I think we did in the Commission, we had a run-up of this legislation for more than a year. We had before a high-level expert group which represented 56 experts from different areas. We really tried, and so this is not just this 1 year, but this is a 3-year process, this AI Act. We really try to be as inclusive as possible and try to listen to as many people as possible. And this event today is, of course, one of the opportunities to listen and to learn. we have really, and I think yet you can see, we have had a very wide public consultation with more than 1,215 replies and 400 position papers. We have really studied them carefully. You can see our report on the web. We have now a feedback exercise ongoing, so you're all invited to still submit your position. We will then submit these positions to the co-legislators, who are in which hands now this file is. And of course, as well, I don't want to go now too much into detail. Disability accessibility for people with disabilities is of course an important point. We're always happy to improve, and this will be part of this process now, which will start with the co-legislators. But we have tried, I can really assure you there, to listen to everybody and to be as inclusive as possible, and as well to look at the different needs of different groups. But that, I think, is as well the use of this kind of event, that we can still look if we might still have overlooked something, because as Dragos says, nothing is perfect. Thanks.
Thank you, Mr. Gross. And yes, clearly a call for more engagement and joint conversations. So +1 for that. And Mr. Tudorache, very briefly.
Well, I think clearly there's never enough consultation. I said that for this particular process, I think the approach that the Commission has taken was the right one, with the white paper and opening it up to everyone that wanted to be consulted. But of course, there's also the issue of whether everyone can be, for reasons that I mentioned earlier, can actually be involved in the process. And there is never enough transparency in consultation, no matter how much you try. I think we have to make up for it as much as we can, because, as I was saying at the beginning, the work that we do right now and the kind of rules that we are devising right now, not only that they will govern how the digital society of tomorrow will look like, and where I agree with what everyone else said, we have a duty of diligence that we don't simply replicate the injustices from today's physical world into the digital world of tomorrow. That's an absolute must. And everything we can do for that, from the way the data sets that would be used for developing these technologies and these algorithms, to how we would be enforcing the rules that we will set up through this particular act and through all of the other related digital regulations. I think we must keep that at the heart of our objectives. We simply cannot have not even the same as what we have today. We have to strive that, again, through this transformation, through this digital transformation, tomorrow's society can be at least 2 centimeters better. Certainly, we cannot afford to make it worse than what we have today. Particularly on the issue of, and I'll shut up, I'm sorry, I know I speak too long, particularly on the point of involving the Romani community, which is a very, very important point. We've been postponing it, unfortunately, for a couple of months, but we will have a dedicated hearing in AIDA on bias. So it's going to be specifically on bias and biases and injustices in AI. And I think that could be the one event where it would be very important to listen also to the representatives of the Romani community on this. So I can only invite the participants that spoke before to send their data to us, to the AIDA Secretariat, or to myself, to my office. And for I don't know exactly, according to the calendar of AIDA, when the event is. I think at the beginning of autumn. But again, it's important that we have these details, and we will do our best to involve you in that particular event. Because again, it will speak precisely on the issue of biases, and I think it's very important to hear their perspective also.
Thank you. And definitely much more to be done also to work with the community to make sure we were talking about discrimination, harm prevention as well, beyond mere bias. And so to close this event, I'd like to ask our 3 other participants, Sarah, Richard, and Sophia, to really give 1 sentence each. You can, no long sentences with 2,000 commas try to narrow it down to 1 last statement, and then we must unfortunately close. So Sarah, if you want to take the floor.
I'll do my best. Thank you for the very interesting event. I think one thing I will leave with is we're seeing some positive attempts by the Parliament to move forward and see how this regulation can address the sort of structural, very social concerns that we see with artificial intelligence and the deployment of artificial intelligence in our lives. I can only hope that this continues. Studies on bias, I think, are important. So must be the structural impacts, how AI systems perpetuate other types of harms, particularly on those already marginalized in our society. The last thing I will say is that there is a real need for the Parliament to speak to a really wide range of communities, organizations, particularly on these questions of governance around how the Act is regulated and monitored, but also how the prohibitions are formulated to be as wide as possible to ensure that, as you say, Marlena, harm is prevented rather than a situation where we allow harm from AI technologies to occur and then place the burden on already marginalized communities to document, prove, and try and dispel these harms. So with this, I'll leave you.
Thank you. And to add on that, especially in the case of algorithmic harm, when remedy is even more difficult to access than in our usual system. But I'll leave it as that. Richard, one final word.
Thanks. I'd like to end by reflecting a little bit on what Dragos said at the very start, which is that the EU has in mind the possibility that this could become a global instrument and should set the trend for what other countries and regions do. And I would perhaps on that note that it's worth thinking about the risks to different groups that exist in different parts of the world as well. And if this legislative framework were to be emulated, what that might mean. To give one very quick example, technology which can predict your sexual orientation might just mean targeted ads in Europe, but it could mean a death sentence in other parts of the world. So I would encourage the Commission to really think about that when they're developing this instrument.
Absolutely. Thank you, Richard. And especially in Pride Month, let's not forget the adverse impacts that AI systems do have on LGBTQI community. So thanks for that reminder. And Sophia, you opened us up so you can close us off as well. Go ahead.
Well, we've had the opportunity to discuss about developing an inclusive consultation process. But before we even get to that step, like, what do we do with all the other civil society organizations that don't get to be in today's events, that don't get to be in other events, and not because they didn't have time or they can't or whatever, just because they don't see the harm in AI and all these things. AI is widely presented as, like I've said in the beginning, the tool of the future. It's going to make everyone's lives better. And also it's very tricky for an organization, for civil society organization that use technology a lot, and really like technology and social media a lot to make their organization exist. So how can we easily see the harm in technology and AI and then be part of this conversation even before we get into trying to understand it? So thank you very much.
Thank you so much. Absolutely. And we talked a lot about biometrics today, didn't get into algorithmic driven content moderation and other issues related to AI that have many other impacts that can be just as harmful. So with that, recognize that we did go over time. I really, really appreciate everybody's commitment to this work and the time and resources you put into it. Thank you to the speakers who really, without whom we wouldn't be here today, sorry, and the participants. And please reach out, stay engaged. You have our contact information. You can look us up also at ecnl.org. And yep, thank you so much. Hope to see you soon and have a great rest of the day.